is a partner in the school law firm of Miller, Tracy, Braun, Funk, and Miller. Brandon frequently presents at local, state, and national conferences on issues of school law. He serves on the executive committee of the Illinois Council of School Attorneys. Welcome, Brandon. And I'm Linda, your webinar facilitator. I'll be behind the scenes making sure that everything runs smoothly, as well as interacting with you in the chat. So let's get started.
Well, thanks for hanging out today, everybody, as we think through all the things going on out there in the world of school law that relate to technology in different ways. And so in our time together, we're going to try and cover several things today. My main focus is really going to divide this into a few parts. We want some data privacy reminders. What are those frequent phone calls I get or frequent issues that are crossing my desk when it comes to some of our data privacy issues, and we need to be thinking about that. We also have some federal guidance that has come out this fall, federal guidance on artificial intelligence and the use of AI in schools, and some very recent cell phone guidance and cell phone policies in schools that we want to make sure you're thinking about and have on your radar. And we've got some other legal trends out there that are impacting technology in the school setting in different ways. And that's how we will round things out today. So if you've got questions, please pop them in. We'll ask them before we move on to the next segment or the next topic as we walk through things. But I think the right place to get us started is one of the most important legal issues for us when it comes to EdTech, and that is data privacy. And I kind of just have 5 practical reminders to be thinking through as we are engaging in our district with our EdTech committees, what we need to be thinking about. And the first is to make sure that we are prioritizing practical training. I think it is a frequent issue that we are engaging in training that may or may not be practical for the people for whom it is intended. And so I just think there's some basic questions that I want to make sure we can answer as a school district. To what extent are employees trained in a practical and effective way to understand some of these basic data privacy concerns? You have employees in your organization that run the continuum in terms of their level of understanding and sophistication when it comes to these issues of data privacy, data security, engaging in those basic reasonable security practices. So think about your most tech-savvy employee, but also your least tech-savvy employee, and are they being trained in a practical and effective way? I think sometimes just checking the box to say they got a training that meets some of the basic requirements might be enough to stay legal, perhaps, but I want it to work. And so are we engaging them in real ways to understand these data privacy issues that are out there and to understand those reasonable security practices? When they're taking their laptop from the school home and connecting to their home Wi-Fi and other factors that come into play, what kind of training and conversations are we having in a way that's really practical? And what we know about effective training for school employees is that it's going to be ongoing, hands-on, with regular feedback and coaching. Not just a one-time drop where we never come back and mention it again. As adults, we move on to the next thing. And so the more practical and hands-on it can be, having that ongoing and regular feedback and coaching is really an important way to make that work, to make that effective. And so I think that's first up, on my list, to make sure that our training for all of our staff are really, meeting that practical and really is helping them understand what they really need to know. I think that's really important. Number 2, and I think this is an important one, to make sure we've got the right setup to manage electronic file access. And I think this comes to us in a few different ways that I have seen this become a legal issue for some schools and for some school employees. The first is who has access to what. What is clear under FERPA and the Illinois School Student Records Act is that not every employee needs to automatically have the right to access electronic student records for every single student in the district. Only those for whom they have a current demonstrable educational or administrative interest. And so there have been some complaint findings saying, open access of every employee to every student's information in the student information system is beyond the boundaries of what FERPA or the Illinois School Student Records Act would permit. So we need to be thinking about what information employees really need. So they need the information they need, and they don't need the information that would be outside of their FERPA circle of trust. I think that is an important one for us to keep in mind and thinking about. I think the other thing we need to be working on, and I think this is connected to the first point about some practical and effective training for employees, is how are we monitoring and training and communicating with employees about their cloud storage choices? Because I think one of the things that I am seeing be a more frequent issue and concern is having situations where employees are saving student information in unsecure locations. They're saving it to their personal Google folder or some other less than ideal cloud storage option, or certainly one that's not affiliated with the school is also important. There was a relatively recent decision in Missouri where the Supreme Court of Missouri upheld the dismissal of a tenured teacher in part for saving student files in her personal Google folder as opposed to keeping them in the school's approved and appropriate and FERPA compliant, electronic storage or cloud storage system and on their network. So I do think this is happening more than you realize, where teachers are, for practical ease of use purposes, saving student information in their own Google folder so they can access it at home, saving it in a Dropbox that may be associated with a personal account, or other ways that may not be meeting our expectations by policy or those reasonable security practices required by SOPA. So I do think it is important for us to be thinking about how are we monitoring and training and communicating with employees about their proper cloud storage choices. I think that is an important one. And then I think part of this is also recognizing that we need to make sure that whatever system we're using for document storage, including emails, allows us to be ready for a comprehensive records request. If we're getting a request for records under FOIA or under FERPA, and we need to quickly be able to turn around that records request under appropriate search terms, are we ready for that? Is our system capable of doing that? Especially knowing that we're going to have to probably review a lot of those for required redactions or other things that might be necessary. So how are we saving it? What is our search situation if we need to be able to search for a particular student's name or a parent's name or a particular search term that's asked for under FOIA? Are we ready for that? And one of my concerns from a legal perspective is we get the request and then we're having our tech folks at school saying we can't do that. And we've got to make sure our system allows us to do that. There's just not a way around that. And so if we're putting systems in place that are not going to be manageable and not manageable in the time frame anticipated, FOIA typically is a 5 business day turnaround. School Student Records Act is a 10 business day turnaround. That's not only collecting those records, but having the chance to review and redact and prepare those. So I think that's the second piece in terms of the big picture we want to be thinking about, is making sure we've got the right systems in place for managing electronic files. Third on my list, are we using our EdTech committee effectively? Our policies, if most Illinois districts are using the press policy service, it says you're going to have an EdTech committee. And I want to make sure that we are using that effectively to make sure at a minimum annually we're reviewing and discussing the policies that they need to be thinking about as a committee. How is it working? Is it effective? Do we need to change things? And I think that we want to make sure that while certainly the press policy specifically designates that committee to be looking at our SOPA policy, I think there are other relevant policies that same group ought to be looking at. our student records policies, our acceptable use policy, other things that may be relevant to the use of tech at school. So I want to make sure that committee is being used for that. And then I think part of what I want that committee to answer is there a gap between the written policy and what we're actually doing, its implementation? And then I think the question for that committee is this a policy issue where we need to tweak our policy? Or is this an implementation issue where the policy is correct? We just need to fix what we're doing on a day-to-day basis to make sure that we are not only meeting the requirements of the law, but what our own policies say, which is important. Number 4, SOPA was not a one and done, right? This is an ongoing obligation. So I think a lot of districts did what they needed to do to get their SOPA agreements in place and posted online back a couple years ago at initial compliance, and then sort of forgot that it exists. We can't forget that it exists. We've got to make sure that we are continuing to keep those agreements updated and posted as we are using new operators, new apps, new programs, new websites that might have any covered information in it. And again, shout out to LTC and the Student Privacy Alliance for creating a pretty user-friendly option for that. So I encourage you to take a look at that. That's a great way to do that. The link to that there is scrolling. So make sure that if you want access to that, that's a great resource to be able to use to help manage those agreements for us. And then number 5 is more of a preview. Be ready for the new Illinois and DPA. The National Student Data Privacy Agreement is there through the Council of School Attorneys and IASB. We've got the Illinois specific agreement customized for our state law requirements to the National Data Privacy Agreement. That's part of that. I know that version 2.0 is in the works. We all anxiously await that. I think those folks who are working hard to create that, so be ready for those changes. We'll probably be updating a lot of those SOPA agreements once version 2.0 comes out at some point. So those are data privacy pieces. So I don't know if anybody has any questions or any questions popped up on those data privacy pieces before we move on to some of the federal guidance that's come out recently.
Hey, Brandon. Thank
Hi
you
there.
so much again for being here. I just wanted to do a couple bits of housekeeping. So first is I put the link to his presentation in the chat. It's also here at this bit.ly December 24th LTC webinar. You can grab all the links in this presentation at that link there. But yes, we did have one question that popped up in the chat. So it was asked, is there a minimum time period emails should be saved for a FOIA request? Should emails be saved past this timeline?
So I tend to look at a couple different factors that are out there in terms of how long we are keeping various records, because depending upon what the email is about, the subject matter of the email is going to dictate that. And it's hard to have a timeline where we have different emails for different lengths of time. So I might go to the longest period of time the law might suggest. Now, for student records, those temporary records would have to be maintained for a minimum of 5 years after the student leaves the district. So that's not 5 years from today. It's 5 years from when the student leaves the district. And Title IX now has a 7-year record keeping requirement. So for me, that's the minimum. As I'm starting to think about what would be the minimum amount of time that one of our students in the district might be with us. If we're a pre-K to 12 district and we've got some young kiddos, that might be many years from now, and then add 5 when we expect their graduation. I think that's the time I would be thinking about. And remember, if we're going to destroy records, we have to get permission from the local records commission, among other things, before we could delete those records. ISB's been pretty clear in their guidance that deleting electronic records is the same thing as destroying paper records and requires us to have that disposal certificate from the local records commission as well. So there's a few steps we would have to go to before we could just hit delete on that and make sure we're keeping them for, that might be a very long number of years, right? When we think about a 3-year-old coming into preschool, And if they stay till they're 22, that's 19 years from now, and add 5. So that's 24 years from now. So that's 2048. That's what I'm thinking about. So I think the better answer is I'm not worried about deleting anything. I'm just keeping it.
Great response. So I think that's it for the chat right now. But if anyone else has questions in the chat, please go ahead and pop those in. Don't be shy, and we'll answer those in just a few minutes here.
Very good. Well, let's shift gears a little bit to focus on a few federal guidance documents that have come out. And the first topic I want to spend a few minutes on here is looking at our federal AI guidance. Now, we talked about artificial intelligence when I did a webinar in the spring. That's probably still online through LTC if you want to go back and watch that if you didn't join us back in, I think, May when we talked about it. But we did this fall get a couple additional updated guidance documents from the Federal Department of Ed that I think are worth looking at. Now, obviously, we know with all federal guidance, there's going to be a change of administration coming, and so maybe there could be shifts in this, but I do think some of these are pretty straightforward things that we ought to be taking a look at. And so the first that I want you to have on your radar is the October toolkit that was released from the Department of Ed's Office of Educational Technology. It's a toolkit for safe, ethical, and equitable AI integration. That link is here. It's also scrolling on your screen if you want to take a look at that. I'm not going to go through that from beginning to end, but I think that it's a 74-page toolkit that's supposed to help us think about some of the practical considerations and legal considerations and pedagogical considerations as we are incorporating and designing policies related to artificial intelligence and other AI apps. Really, there's 3 sections to that guidance. And I encourage you to take a look at it. Mitigating risks with privacy, security, and civil rights, building a strategy that's meeting students' needs, and effectively using it to boost teaching and learning. So just to give you some ideas of the types of topics the toolkit addresses, first, in those mitigating risks, when we talk about student rights, I think there are a couple pieces that stand out. One of those is monitoring privacy and security. One of the concerns is that some of those AI, applications are data mining and may have some unintended disclosure of private information if that's part of the input that they are addressing. And so we've got to make sure that our use of any AI program is going to maintain some of those privacy and security considerations that are there. They've got some practical thoughts on that. It's ever changing, obviously, but that's there. Also some accessibility concerns to make sure that those programs are not, skirting our obligations to make sure that any of our online programming or applications are accessible to students with disabilities and meet some of those requirements. And then they're concerned about bias and discrimination that might exist, especially if the algorithm is using biased data or data that has disparate impacts in it. We'll come back to that in a little bit with OCR's guidance. There's some specific examples in an additional guidance document on that topic from OCR. So we'll come back to that specific issue. But I think so we'll revisit the accessibility and bias and discrimination piece with OCR's guidance in a minute. But I think for purposes of this document, that privacy and security piece is paramount. OCR's guidance, I think, is more specific when it comes to those accessibility and bias issues. The second is building a strategy that's meeting students' needs. So the concern of the Department of Ed is that making sure that we're using AI to build on our instructional core, not replace it. And so we want to make sure that as we think about interventions that may be AI enabled in different ways, that we are using that in a way that's not replacing the human element, but building upon it and using it as a starting point and using it as a tool where it can be. And I think that's an important factor for us. And then again, those effective link to teaching and learning, building that AI literacy for educators so we don't have teachers using programs they don't understand what it's doing and how it's doing it, making sure our responsible use policies are up to date and reflect what's happening in real life. Again, an important role for that EdTech committee as we look at policies, as I mentioned earlier. And then some of those things we've got to be constantly being prepared to react to. Cyberbullying, deep fakes, threats, and sort of pushing back against the idea of something new versus useful. Just because something's new doesn't mean it's useful yet, and so as we are trying to find the appropriate pedagogical use for AI, that we want to focus on the parts of it that are useful, not just the flashy parts that are new, and I think that's an important consideration. So that's the first document I want to make sure that's on our radar and we've taken a look at. The second one that I mentioned is OCR. The Department of Ed's Office for Civil Rights issued a guidance document here just in November, a few weeks ago, on avoiding the discriminatory use of artificial intelligence and really looking at that more from the civil rights perspective. That link is here. That link is also scrolling if you want to grab that document and look at it. In that document, they've got some examples. And so, we kind of covered some of the issues that might exist, whether it's bias, accessibility, algorithmic discrimination is an issue that OCR is concerned about as well. And so I've taken some of the examples. These are examples that OCR gives of, concerns they might have, situations where the use of AI might be unintentionally leading to discrimination or discriminatory or disparate impact on certain students or student populations. So let's talk about some of the examples that they gave. The first one is a high school English teacher using an AI detector app to prevent plagiarism, but the app has an error rate that flags English learner students disproportionately. So they're concerned here that there might be a discriminatory or disparate impact on English learner students because that plagiarism detector is perhaps having an error rate with students who don't speak English as a first language. And that would be an example, OCR says, of a potentially discriminatory or disparate impact use of AI. Another example they give, also on the English learner front, is a school district using an AI program to teach English learner students while non-EL students get instruction from a teacher. And so again, they view, hey, if I'm a student who's an English learner student, my only source of instruction might be through this AI program, whereas students who speak English as a first language, they always get a real life in-person teacher, and that disparate impact or different treatment might be evidence of discrimination. Using an AI program to translate for parents who don't speak English, but it's ineffective. And so I think that's the piece, is that if we're using a program that's not going to truly be effective, then that might be a barrier to access and an example of discrimination. Keep in mind that our Illinois regulations, our special ed regulations specifically, have rules about if we're using an AI program to translate an IEP or other documents for parents, we still have to have a human being certify in writing that they've reviewed it and that is an accurate translation, those types of things that are out there for us. So AI can be a great tool. Its ability to translate is coming at leaps and bounds. But we still have to make sure that it's effective and not a barrier for communication for those parents who don't speak English. Another example they give is using AI for facial recognition in a safety program, and that facial recognition technology is consistently misidentifying Black students. That's an example, again, of discrimination or disparate impact, an example specifically included in OCR's guidance. Another example, the district is using an AI program to make default academic schedules for students, and because the AI program relies on historic data and demographics, disproportionately assigns male students to computer science classes compared to female students. So an example here of historic bias being part of the algorithm, and therefore the inputs or the outputs that we see result in disproportionate impact and bias. So an example of algorithmic bias that they are concerned about for that. And then I think the last example from OCR's guidance, there are others. I just picked out a handful, and they've got great discussion about these within that guidance document. Using AI to closed caption a science course for a student with a hearing impairment, but the program inconsistently translates advanced science terminology in that class. I think that these real-time translation and closed captioning have become, have again progressed with leaps and bounds. 10 years ago, there was a lot of litigation over the use of these programs because they were so expensive and almost required a real-time human being, court reporter, to take down that real-time closed captioning. The AI options, even just using PowerPoint and turning on subtitles, it is really, really good, but not perfect. And I think when we get into certain situations, like an advanced science class where there might be more acronyms and terminology that the AI program may not be familiar with, if it's not translating those consistently, then that might be a discriminatory option if we're using that. So that's another example that OCR provides. So I think that that's an important piece on the AI front to be thinking about, the federal guidance. So I encourage you, as you're looking at in your district, making changes to any policies related to AI, handbooks related to AI, training teachers on some of these ideas. I'd make sure we're looking at both of those guidance documents that came out here in October and November, because I think those are going to be really important tools. And I think ask a lot of the questions we need to be thinking about as it comes to understanding some of the legal parameters and the practical parameters of the use of AI. As some of you heard me say before, I am pro AI, but pro AI understanding that it's an always evolving technology, and we need to make sure we're using it for its intended purpose, not to replace some of the things we still need the human element for in the educational context. We've got one more guidance document that OCR has, or the Department of Ed, has gotten off of its shelves and given to us here recently. And just here in the month of December, we've got a playbook for student personal device policies. So hot off the presses, the Department of Ed's Office for Education Technology released this guidance, this toolkit or playbook for the kinds of questions we need to be asking as we think about cell phone policies. And I think some of the language they use is interesting. I'll be honest, when you take a look at this, and again, I encourage you to read it, please do, as your district is considering, policies around this. The Department of Ed doesn't give us a lot of answers, but asks a lot of questions, but they certainly recognize that there is concern, that they believe that the use of screens and cell phones and personal devices by students is impacting them in both academic success, impacting their ability to maintain focus, concentration, to maintain emotional balance in stressful situations, but also, impacting things like multitasking and other factors that are taking us away from being focused. That if a student looks something up on the internet on their phone while they're supposed to be reading a book, it may take up to 20 minutes to refocus, right? And so there's an academic impact on this, but then they also are concerned about the mental health and well-being piece and the impact on that. And so that there are detrimental effects of social media on students' mental health that impacts school in very real ways. We know there's schools that are, looking at litigation against the social media companies for the impacts it's having on schools and things. And we'll watch those carefully as those play out in the courts. But I think that what this particular guidance document does is gives us a framework to ask the right questions. So as we as a school are trying to develop policies about limits to student cell phone and device use, and other things that relate to that, what are the right questions to be asking? And so, the questions that they put, and then they've got discussion about this. And so I encourage you to go again. I'm not going to just read the document to you. I don't think that's a useful part of our time, but I do think that, it's important to go back and be thinking about, as a district, when do we want students to have access to their phones during the day? At any time, at certain times? Are there times when we want to make sure it's specifically limited, times when it's specifically permitted? What are our rules? When can students do that? And what's going to be our policy and how are we going to implement that? The second is if phone use is not permitted at all or at times, where and how are they going to be stored? and thinking about what our approach is from that perspective. There are lots of different vendors and companies and tools that can be used related to that. And so many of them have pros and cons. And so that's things that we locally are going to have to decide what we're going to do with that. The third, how are emergencies or dangerous circumstances handled? How do parents and children communicate? How and when do schools and districts communicate with parents during emergencies? I think that's an important component. That's one of the things that's been true in Illinois. When we look at the evolution of our school code going back 25 years ago. 25 years ago, the school code actually required school districts to prohibit cell phones and pagers on school grounds. And after the Columbine shooting in 1999, that was changed. And so we certainly see some legal changes related to that emergency 25 years ago. But as a cell phone or a pager in 1999, I can attest, is not the same thing as they are today. And so finding ways to communicate and how that works in emergency is part of that. Another area that we would think about from a policy perspective is protecting the rights of students, including students with disabilities. So if students need access to their phone as part of their IEP or 504 plan, do we need to write that into the plan, and what would be the circumstances where they would need that for some of their accommodations or services, or other student groups like English learner students, if they're using it for things like real-time translation or other factors, would those be considerations that we would have under policy? What are the consequences? So is this a place, I think one of the concerns here is that, this could be a situation where we have discriminatory or disparate impact in terms of its implementation, and making sure that we're not having, school exclusion has adverse consequences. And so we don't want to always have students being removed from school. So what's going to be our policy on that? Does that policy vary based upon age of the student? Are we going to have a different policy for a first grader than we are for an 11th grader? Probably. And what does that look like, and what's its purpose? Who is responsible for monitoring and enforcing? Is this going to be the teacher in the classroom enforcing it? What's going to be the process for that? What training are we providing to staff? What training are we providing to students? How do we roll out our policies? How do we communicate that with our community? And then how do we decide if it's working or not? Because sometimes we roll out a policy that sounds good and it may or may not be effective. And so what's going to be our process for revisiting that and having that policy evolve to make sure that it truly is being effective for its intended purpose? I think those are important considerations, important factors for us. So I think this guidance is an important one, and I want to make sure that it's on our radar. So please take a look at that, especially if your district is thinking about making changes going into next year in terms of handbook or cell phone policy. It's a front burner conversation that a lot of districts are having, and I think it's a good time to make sure you're including that guidance from the Department of Ed as part of your considerations. Beyond those, we've got some other, I think, trends. So what else what's the kitchen sink part of this? I think we've got a few different topics I want to spend a few minutes on, just to make sure they're on your radar. One of those are the web accessibility rules. So we do have specific regulations on web accessibility to make sure that our online content and our electronic content meets the basic accessibility requirements of the ADA and 504. Those rules were published last April. They took effect in June. Compliance is required by 2026. So just, it's not I don't want to put it too far on the back burner because there may be a lot of things here. But remember here when it comes to our content accessibility guidelines, that includes password protected content available to students and staff. So as your teachers are using things like Google Classroom or other online sort of behind the wall content that's not maybe publicly available, but privately available, that those also have to meet the accessibility guidelines. So let's make sure that we understand that that's going to be true when it comes to those web accessibility rules. There are some exceptions to it. But beyond that, we know that those requirements are going to be there. So make sure we are planning for and training for those web accessibility pieces. So that's topic one. I want to make sure is on your radar. Topic two is the tried and true social media piece. And for purposes of our conversation today, I want to talk about the employee social media piece in a few different ways. What the adults are doing. We spend a lot of time on what the kids are doing. I want to focus on the adult piece here. We've got some cases since we were last together last spring that I think are worth talking about. One of those is the Hicks case from the Seventh Circuit. This is an Illinois case from the Seventh Circuit Court of Appeals, so binding here in Illinois. And this deals with whether or not a public employee, like a school employee, this case it was involving the Department of Corrections, but it would be the same legal analysis for a public school employee, whether or not the posts to his personal Facebook page were protected by the First Amendment, protected from discipline from the employer. So this is an employee who on his personal Facebook page had a lot of statements that were politically charged, comments about Islam, about Jewish people, about transgender people, about Latina people. There was a prayer to allow him to participate in an overthrow of the government, among other things. The Chicago Sun-Times kind of did an expose of employees of the Department of Corrections and what's on their Facebook pages. This was published in the newspaper. After that, he got a 10-day suspension. He sued, saying that suspension violated his free speech rights under the First Amendment. Now, a couple things that are important to the court's analysis is that his Facebook profile was publicly accessible. He did not have it set to private, where only his approved friends could see it. Anybody in the world could view its content. He listed his employer and his occupation, and had a photo of himself in his uniform as one of his profile pictures. Those were important factors for the court here. The court here ultimately sides with the employer, saying that the Department of Corrections' interest in efficiency and preventing disruption outweighed his interest in his Facebook posts that were in question. Now, again, while they said he was speaking as a private citizen on a matter of public concern, there's then still a balancing test, and the balancing test here favored the employer, and the speech was not constitutionally protected from discipline by the employer for a few reasons. They said, first of all, by espousing disparaging views about groups that would be present in the staff population and the prison population or the school population, but that would impact work, that it threatened to erode community trust in the department, like it would with the school, and it might create legal exposure where they're already defending lawsuits for discrimination on some of the bases that were addressed. And the prayer to participate in a government overthrow was also a factor, as well as the fact that he was a supervisor, and so he needed to set an example for other employees. But the court also really was concerned about the fact that this was a public profile that listed his place of work, his occupation, had a picture of him in uniform, that would allow someone to associate his post with the department, and therefore that furthered the department's interests in discipline or regulating what's on his personal social media. So the court here granted summary judgment to the employer, saying that they did not violate this employee's First Amendment rights. And I think it's important that employees understand if they're going to have their profile set to public, and what we post may not automatically be protected by the First Amendment if it is impacting the employer. We've got a case here just a few weeks ago out of Oregon where a cross-country coach, who was also a special ed assistant at the school, was removed after he posted, made some posts related to transgender students' participation in athletics. And here again, the courts denied him his injunction and that it didn't tip in the coach's favor. So again, no automatic protection to those things in those posts. So I think it's important that we come back to practical training for employees, not just on data privacy and not just on reasonable security practices, but understanding the limits to where the line is with their own personal social media is an important factor for us. So some recent cases on that. We also got a decision this fall from the DC Circuit Court of Appeals as it relates to filtering content or deleting comments on official social media. So in PETA versus Tabak, this is a lawsuit brought by PETA, the animal rights advocates, against the National Institutes of Health and its director for deleting comments of these particular individuals from the NIH's Facebook and Instagram pages. The NIH had a social media moderation policy that prohibited off-topic posts. To enforce it, they had keyword filters that would automatically hide comments based on certain keywords. And some of those comments were the terms animal testing and cruel. And so that meant that these individuals' comments were automatically filtered out and not viewable to the public. And here the court agreed that the comment threads were a limited public forum because people had the ability to post comments, but that the off-topic comment was not unreasonable, or that it was not reasonable and was therefore unconstitutional because it prohibited some potentially protected speech. The court said that the off-topic policy, as implemented by the keywords, was unreasonable because it was inflexible and unresponsive to context. And that these were situations where because there was no manual review of the comments to restore otherwise on-topic comments that might have been removed, and that the keywords here, there was no way for someone to get their posts restored absent a lawsuit. And they found that those filters violated the First Amendment, and that they were not viewpoint neutral and censored certain speech that may have been protected speech. So again, we want to be careful about how we are putting our filters in place. If there's an automatic filter, if we've got keywords that would automatically get that comment hidden or deleted, we've got to make sure that that's not being implemented in a way that's so inflexible. That might also be, removing protected speech under the First Amendment, because when the public comments on our Facebook page as a school district, that is perhaps a limited public forum where there are some First Amendment implications if we're going to allow comments at all. So I think that is an important consideration. Closely related to that are the Supreme Court's decision in Linkey versus Freed, which was decided simultaneously with O'Connor-Radcliffe versus Garnier, which was actually a school case. Both Linkey versus Freed and O'Connor-Radcliffe versus Garnier were decisions of the Supreme Court related to public officials and, again, deleting or hiding comments on social media. These cases, though, specifically went to whether or not a public official's allegedly personal social media account was a personal account or was an official account. Linkey versus Freed, where the Supreme Court issued its more complete opinion, and O'Connor-Radcliffe, basically they said, we already decided this in Linkey versus Freed, so take a look at our decision in Linkey versus Freed. This case involved a city manager, but again, we could easily put this in context of school administrator, school official. Mr. Freed was the city manager who had a Facebook page that he sometimes posted about city business on, even though it was allegedly his personal account. And so the Supreme Court created a standard for when a social media account is really considered official versus personal. And it is not how you label it, right? It is how you use it. They said it might be an official account where hiding or blocking comments could violate the First Amendment if that official had actual authority to speak on the unit of government's behalf and purported to exercise that authority in social media. So for example, here, when the city manager was posting about COVID restrictions in the city on his Facebook page, and people were asking him or commenting on that in his capacity as city manager, it didn't matter that he wanted that to be his personal page. What mattered was the form and usage of that account. And so we want to make sure, just because we're saying it's personal doesn't make it personal. It's how it's being used, and that's a fact-specific undertaking. So, Michelle O'Connor-Radcliffe, who was one of the parties in the O'Connor-Radcliffe versus Garnier case, who was a school official in California, since that case, put this disclaimer on her Facebook page that says, this is my personal page run exclusively by me. All views on this page and in every single post are my own and do not constitute official government speech nor represent the position of the school district or board, and says see Limke versus Freed. Does this disclaimer help? I don't know that it helps a lot. I mean, I think it creates a presumption. This is my personal page. This is not my official page. But again, the Supreme Court said we don't just look to your claim that it's a personal page. It comes back to its actual function and use. Are you actually using it to further any official school business? The only real school-related case that we have interpreting that to this point is a decision this fall out of Maryland, the Foldy case, where you had a local journalist who was blocked by an X account or Twitter account. I still say Twitter because I'm that old, but we know that now Twitter's official name is X, so apologize to X. But here there was an X account operated by school staff. It was the MCPS Staff Pride account. So it was an LGBTQ group of faculty members in the Montgomery County, Maryland school district. They had an X account, and this local journalist was blocked after publicly criticizing the board's incorporation of certain LGBTQ books into the curriculum without an opt-out alternative. A decision, by the way, which is on appeal to the Supreme Court, but that's not for today's purpose. And so the question is whether or not that Staff Pride account was an official school account for First Amendment purposes. Were they using it for official school business related to the school activities, or was it more of a personal account not affiliated with a school? The court said here that this did fall within the school's jurisdiction, that it did, therefore, that the members of this group were not only cloaked with authority to speak on the school's behalf, but actually did so via the X account. And so there's a potential First Amendment issue here for that account blocking that local journalist. So we see that playing out. I mentioned the Supreme Court. We've got a case that might be important to us in the EdTech community for sure, and that is whether the E-rate program is unconstitutional. So this is a case the Supreme Court has decided to hear. So we'll have argument this spring with probably a decision next summer. The issue here is kind of interesting because it takes us back to kind of an old school constitutional doctrine. This would, in fact, be historic. It would be almost 100 years since the court would have used the non-delegation doctrine to strike down a federal program. The last time we saw the Supreme Court using that was back in the early 1930s to look at the constitutionality of some of the New Deal programs by FDR. So really would be interesting, in light of the Supreme Court decision this year in Loper Bright overturning Chevron deference. This could have a big impact on federal authority and the authority of federal agencies. But in the school context, we're looking at it narrowly. Will E-rate still exist? Because that's an important funding source for a lot of our programs in the EdTech community. I think there's broader implications from a constitutional perspective beyond just E-rate and the school world, but certainly this could have an impact on our funding sources and E-rate as well. So we'll anxiously wait to see what the Supreme Court does with that. That will be interesting for us. And we've left a few minutes for questions. So I don't know, Linda, if anybody else has popped some questions in, or now is a time that if there's questions on those topics or anything else, I'll do my best to answer them in the few minutes that we have left.
I definitely encourage, if you are still waiting to ask a question in the chat, to please do that. We do have a few more minutes here before we're officially done with our webinar, so we have plenty of time to answer any and all questions. I did want to mention that in terms of the E-rate Supreme Court decision here. We are aware of this, obviously, as at the LTC, and many of you might have interacted with Mindy Fiscus, who is our head of government affairs. She's aware of this too, and I think is working on, coming out with some blog posts through the LTC or some other kind of updates on what that might look like, depending on if they choose this decision versus this decision, putting some of that maybe anxiety to rest, but also talking about some of the real actual implications of if this decision over this one is made. And so keep an eye out for that on the LTC website moving forward here, just for more discussion of the E-rate program.
Yeah, that's great. I will look for that myself.
Yes, I think there's a flow chart involved that she's making, so don't quote me on that, but she is definitely aware of it and wants to provide a little bit of commentary to what might be happening moving forward with E-rate. We did get one question here in the chat. So the question is, if the U.S. Department of Education is eradicated, how would this impact EdTech?
Well, I mean, I think that how that happens will matter. And so is it that some of those functions shift to a different federal agency? Ultimately, I think that's going to be a big lift because it's going to require congressional action to be actually eliminate a federal department and defund it. And I don't know that would pass both the House and the Senate in that regard. I think there are certainly things that could happen administratively. But I think that could have a big impact. Obviously, the civil rights enforcement may take a different approach if OCR is not there to enforce it. Some of these additional regulations may certainly be at question, whether that's web accessibility or other things that might, be given different deference under some of the more recent Supreme Court decisions, and especially if the Department of Ed is not there to enforce. I think part of the reason why we've had so many guidance documents over the last 3 months is that these are things the Department of Ed have been working on. And so the folks have worked very hard on these documents for probably a couple of years, and they want to make sure they get them out before there's a change in administration to see that. I mean, what we did see 8 years ago when we had the change from the Obama administration to the first Trump administration, we similarly saw a lot of guidance coming out in December of 2016 on a lot of different topics from the Department of Ed. And for the most part, the first Trump administration did enforce and follow and kept much of that in place. There were a few things on some hot button topics that were more politically, maybe controversial where you saw that difference. But for the most part, whether that was on issues of accessibility under 504 or other things that might be more EdTech focused, we didn't see that big shift, maybe minor shifts in that regard. Will that be the same now? I don't know. I don't have a crystal ball. It sounds like they're looking to make bigger changes, like, perhaps eliminating the Department of Ed. I think that'd be a pretty big lift. And, we would have to really see the mechanism through which that happens to know whether that's going to have a huge impact, a small impact, or somewhere in between.
I'll just pop one more time up on the screen if you need to grab Brandon's presentation from today and you want to save that. It's a quick link, bit.ly/December 24 LTC webinar. You can pop that in and grab that PDF for yourself, which does include all of the links that he mentioned today. But otherwise, Brandon, thanks so much for being here. I really appreciate your expertise.
Of course. Great to see you again.
All right. For everyone who is still here, thanks so much for joining us as well. And I'm going to go ahead and let you go. So have a great rest of your night and happy holidays.